Hey, you need access?
Hey, I can't believe
Okay, Kyle's
I'm at the
coming.
front.
Okay,
Okay.
bye.
The front door was open when I got
It was open when I got here too. Someone must have closed it. Okay, we are back. And I can screen share. Yay. Somebody jump on. Can you see 1 to 4 family contract?
No,
What do you see?
I see the Facebook page right now, but I can't see
And now can you see 1 to 4?
No.
Yeah? Okay, so it's just a little lag. So I'll put it back on the 1 to 4. We'll wait for Nadeem. I'm gonna go grab a donut too. If y'all need water or coffee, go grab it now. So we're gonna get started.
Yeah, we donut, thank you.
You're not getting one?
Hi,
I have
Sheldon.
some down here.
Oh,
I snacked on the way over.
it's a good thing because I skipped breakfast.
Sheldon, right now we have Adrian in the office. We introduced her yesterday in the newsletter, and she's offering mentoring. She's going to be helping me with mentoring. So, whenever you're ready to jump on that, let me know so I can get you connected to Adrian. He's
I brought the money maker.
Morning.
Hey.
I'll let you partake, huh?
If you want to grab a donut, you can. Coffee or water, do that quickly. I'm going to go grab my sign-in sheet, and we are going to get started.
Or these coasters. Was I supposed to use one of those? Oops.
You're already messing up in the morning.
I know. You said this. I actually just got my boards like a week ago, but I've been licensed for about a month or so. I just didn't know about the boards and the extra fees. So it took me a while to like have to pay for boards now. And then Sharina, she texted me yesterday and she's like, there's still something you have to pay. And I was like, I thought I already paid it. What is it now? But she just said it's our dues for the 2021 that are due December 1st. Which really
Yes.
sucks since I just paid them and I'm like, wow, we have to pay again.
Well, I think they prorated it for you.
Oh, okay.
Because, I mean, I'm not gonna ask you how much you paid, but if it, was it close to 483?
They told me it was 550. Yeah, that's what. But then they only ended up charging me about.
I don't know, it sounds like I'm in that process, cause I have to get them on the board.
Okay, do not get that key fob for the old lock boxes.
Oh, I haven't.
Don't
Maybe
buy
I
it.
will.
It's, I have some of my other key ring. It looks kind of like a miniature garage door opener. It's just a black with a white button.
Oh,
It doesn't work.
something about the one on the phone instead?
No, use the one on your phone.
Instead, right?
But make sure your phone is always charged when you go
Yeah.
out showing, and then you update it while you're at home. You
Okay.
cannot update it if you're in a bad cell area, and you get stupid when you can't open the door.
Okay.
But they try to sell you this little keychain that's supposed to open the old lock boxes. I've never used it. and it was the biggest waste of life. So, if you need one, there's somebody always in the office that's gonna have one. Renee, do you have one of those?
No. Mm-mm.
I got one. We need it. You should know, looking down at the listing, you'll know what kind of box is being used. And if it's an old one, call the agent, verify it, and then, you know, hey, Adrian, can you meet me somewhere so I can grab it? But I've never used it.
There it is.
So it's save $50.
I know. Well, you should figure it out.
Okay, contracts. 10:24. All right, guys, I'm gonna pass this around. Go ahead and sign in so I can turn in my hours to check. This is not a CE class. This is personal. Just wanted to let you guys know I have to turn my stuff in.
Just put 1, 2, 3, 4, 5.
It's on. I have something to say.
Until you get everything done with your license number, take a picture of it, put it in your.
All right, everybody online. If you're online, I know Sheldon's on, but as soon as you hop on, if you'll say Nikki's here or Sheldon's here or anybody, you know, if you guys jump online so that I can mark you present. And it is now 10 after, so we're gonna go ahead and kind of jump in. For everybody who's here, I printed a copy of all these contracts, but we'll just go over them online here as well, okay?
We have questions.
Yeah, if you have questions, just stop me. That's a good thing about being in a regular class. Don't stop me on every question. If you have excessive amount of questions, write your question on your little paper and ask me at the end, okay? I can hear my back, like my lag there, but I want to be able to see the comments. So, okay, guys, contracts. We're gonna go page by page, line by line. It's not gonna be super exciting, but if you have questions, like I said, just stop me so we can kind of chat about the area. Easy stuff we'll kind of breeze through, and again, if there's a question there, just stop me if I'm breezing too fast for you, okay? All right, here we go. So we are going to start with the residential 1 to 4 family residential resale contract. So let's just pay attention to that title there. 1 to 4 family residential contract resale. I know this seems a little bit basic, but 1 to 4 means 1 unit to 4 units. So a single family home, a duplex, a triplex, a quadruplex can all use this contract, okay? Resale means this is a already built, being resold property, okay? Keep that in mind. So there are different contracts, which we won't be going over today, but we can. We'll have other classes for different types of contracts. Today we're focusing on residential 1 to 4, okay? Notice right under that line, it says notice, not for use for condominium transactions. That means no condos on this contract, okay? There is a different contract for condos. Any questions about those things? There is a different contract for land, okay? And there's a different contract for commercial. So we will talk about those another time. And rentals. There's a different, it's not a contract, it's a lease agreement.
Don't spend the time writing this up.
All right, guys. Yeah, don't use this for leases. This is for a sale, resale. So pay attention to those keywords there, okay? Paragraph 1, parties. Parties to the contract mean the people who are involved in it. The parties to this contract are blank. That's your seller's name. When you click on it in zip forms, it will pop up 2 different boxes. So in the paper contract, we just see a flat line. But if you click on that, any yellow spot in zip forms, it gives you a little pop-up box. So there might be 2 sellers. Make sure that you are checking the tax rolls to get those names. Don't rely on MLS that the agent put their names legally correct. This is a legally binding contract, so everything has to be legally correct, okay? So just jump into the CAD of whatever county you're in. If you're in Dallas County, search DCAD, pull the address. You can do the same with calling CAD. If you are not on Safari, you can also, when you're in MLS, click on tax, Realist tax. Realist pulls all the CADs in, okay? But if you're in Safari, for whatever reason, it doesn't work. And if that's the case, jump on the CAD. You'll find what you need there. Legal name of the first seller and legal name of the second seller. Same with the buyer. So the second line says, and, so parties to this contract are blank, the seller, and blank, the buyer. So again, when you click on it, you can put buyer 1, buyer 2. If you are representing the buyer, which is when you're filling out a contract, you're representing the buyer, you need to ask your buyers for their legal names. Tommy Smith may very well be Timothy Smith or Thomas Smith. You need to know. Do they use their middle initial as a legal part of their name? You need to know that, okay? So definitely be asking your clients, especially when you're filling out your representation agreement, ask them, what is your full legal name? That's what we need to have in our contracts. So make sure that you're getting the right information and filling that in completely. So if there's only 1 seller or 1 buyer, you can just put 1 buyer name. If there are going to be 2 or more, make sure that you're filling those in correctly.
Is there one that kind of trumps the other? Like, for example, I find it common in like the Hispanic community where the social will have a name, but then in the driver's license it'll be slightly different.
I think their social security number is the one that trumps
It'll trump
everything. Mm-hmm.
Okay. A lot of people don't carry with them, but
Yeah, well, a lot of times your social has your full middle name in it. So if they just use their middle initial on their driver's license and their full middle name, just ask them, would you prefer your full middle name in yours? Or for me, my name's Renee Nicole Anderson. Anderson is such a common name, but the way I spell my first name isn't common at all. So I only need to use in. My husband, for example, Benjamin George Anderson, has to put his full name because Ben is very common and Anderson is very common. So Benjamin G. Anderson is too common of a name. So we have to use his full name. So just ask your client, because that they'll know. They don't want to be confused with somebody in tax rolls. They don't want to lose the house in a dispute over somebody who has the same name as them, because that could possibly happen. So just ask your client, what is their preference? This is how it's going to be filed in the taxes next time it's filed.
So that's what I was gonna ask you that, because when the closing is happening,
Mhm.
the notary will ask for their legal ID, which is
Driver's
driver's license or passport,
Mhm.
so not the social security card.
Yeah.
Yeah. So it's gonna be your legal passport or.
But your lenders ask for your social security stuff. So it really, what's going to be put on here is what's going to be put in the tax rolls next time. So a driver's license is fine, but ask them what their preference is. Okay. So the parties to this contract are blank, the seller, and blank, the buyer. Seller agrees to sell and convey to buyer, and buyer agrees to buy from seller the property defined below. I know a lot of people skip that little sentence, but this says the seller agrees to sell the property and convey it to the buyer. Okay, that in itself is a legal binding statement. Okay. Paragraph 2, property. The land improvements and accessories are collectively referred to as the property. Okay, so that means the land, the improvements, so the land is the ground, the improvements are the building, the house, and the accessories, anything affixed to the house, is considered the property. Okay, so guys, if curtains are affixed and they're not excluded, they're considered property and they convey with the house. The stove is considered property. It conveys with the house. If you put a bracket TV on the wall and you don't exclude that bracket, that conveys with the house. So make sure that you understand what accessories are, okay?
And some fridges are conveyed, I guess.
Never. A refrigerator is considered personal property. It can convey, but it doesn't have to convey.
What about a built-in?
If it's a built-in with, doors, built-in refrigerators do convey.
Okay.
Yes.
The rule of thumb on TV mounts is if your client wants to take everything, they must fix the wall.
Yeah.
If they want to just leave the brackets up there, then it's good to go. But don't, you never wanna walk into a home with a buyer and have all these holes everywhere.
Yeah.
And you don't wanna look bad as a realtor telling your client you can do that as a seller too.
Remember to exclude brackets. Just exclude them because they're not considered personal property once you fix it to a wall, okay? All right. So the property, paragraph 2A, land. The lot blank. So the lot, block, and addition to every home is going to be listed in CAD, whatever county CAD you're in. You can also click on Realist Tax and MLS if you have access to that to fill in this information. But make sure you do your due diligence. Okay, make sure you check and double check that this is the correct lot, block, and county. While you can get this straight out of MLS, do not trust that. Go and do your own homework because somebody else may not have done theirs, okay? You don't want to accidentally sell the wrong house. It's happened. You're giggling, but if they didn't do their due diligence and just threw the lot block in, or they accidentally mistyped from 1 to a 2 because they did it on their phone, you could possibly sell the wrong house to your buyer. Okay? You don't want to do that. So lot, block, and addition. Make sure you look that up. Addition, so it's always going to say lot 1 or lot A, block 27, the Shire Homes addition. Okay, so there's always like a little wording there of what that addition is in case you're confused of what that means.
And I just had that one offer that I was making,
Mhm.
the two lots together,
Mhm.
they only listed one.
Yeah. So make sure little things like that. If it's double lots, you may need to either put that in special provisions or create a separate contract. Okay. Ask the title company how they want that filed. Again, this is why it's good to use our friends in title because you get to call them and ask lots of questions. If something is wonky or weird, there's always the exception to the normal, easy deal. Not that any deal is easy, but you know what I mean. Okay, so lot blank, blot blank, city or addition, city of. In that next line, you put your city that you're in. Make sure you know what city you're in, guys. There's sometimes you think you're in Plano, but you're actually in Murphy. You think you're in Murphy, but you're actually in Parker. Okay, I'm using examples that I specifically know are just a little confusing where the lines are so blurred. Saxe or Garland. Make sure you know what city you're in. The county of. This is the same thing. Half of Saxe is in Collin County. The other half is in Dallas County. I sold a property that split Dallas and Collin County, like the property did. You need to know that, and you need to make sure that you know which, are they paying both taxes, are they paying both school taxes, and you're telling your clients those things, okay?
What happened with that scenario?
They pay both taxes. They got to choose what school they went to, but they still had to pay both school taxes as well. So those taxes were insane. It was in a couple $1 million neighborhood, but still, the property, there were this side of the street, people were in Collin County. The people right behind them that shared the alley were in Dallas County. But this whole street, like 3 or 4 of the houses split the county line. So they do prorate, so however much of your property is in the Dallas County, you pay that much of the Dallas County taxes, and however much is in the Collin County, you pay that much of the Collin County taxes. So that was good, but fun stuff. Make sure you know what county to list, okay? Known as, so in the county of Texas, blank Texas, known as. This is where you put the street address. not the whole address, the street address, 123 Main Street. Okay? And there's a reason for doing this the way it is, because in MLS, when you put the street address here and then there's a next line, there's a comma and then one more line, not on the paper form, but in here, in the online form, if you put 123 Main Street on the first line, and then right next to it on the second line, you just put the zip code, it finds the address and populates it throughout the rest of your transaction and zip forms, okay? For those of you using dot loop or anything else, I'm not really sure how that works, so you'll have to speak with Adrian. All right, so right after that, you'll see it says address/zip code, okay? So 123 Main Street /zip code. You do not need to put city and state here. Or as described on attached exhibit. So let's just say, for example, my weird property that split 2 counties. It doesn't fit in this perfect box, right? Because it's 2 counties, probably has 2 different lot descriptions, or as Nadim's situation, it was 2 completely different lots being sold as one. You can attach an Exhibit A, which would just be a Word document, okay? Anything that says Exhibit A, Exhibit B, Attachment A, it's just a Word document that you create and fill out. Get with the county assessor's office and ask them how that needs to be described as a legal description, and also talk with your title company, okay?
And you'll show that the 2 different cities too.
2 different cities, yeah. So you need to know which city the county assessor wants it to be listed as, and make sure that that's listed as legal description, so that next time when it's filed that title, it's done correctly. All right, guys, moving on. Paragraph 2B, improvements. The house, garage, and other fixtures and improvements attached to the above described real property, including, without limitation, the following permanently installed and built-in items, if any: all equipment and appliances, balances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, attic fans, mailboxes, television antennas, mounts and brackets for televisions and speakers, heating and air conditioning units, security and fire detection equipment, wiring, plumbing, and lighting fixtures, chandeliers, water softener systems, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, outdoor cooking equipment, and all other property owned by the seller and attached to the above described real property. That's what your improvements are. So if you have questions, read paragraph 2B. All of that stuff conveys with the home, unless you exclude it, which we're about to go over where to exclude that, okay? Questions? Great, moving on. Accessories. The following describe related accessories, if any: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, draperies and rods, door key, mailbox keys, above ground pool, swimming pool equipment and maintenance accessories, artificial fireplace logs and controls for the garage doors, entry gates, and other improvements and accessories. So there's a definition of what your accessories are, okay? So you see, all of this stuff must convey unless you exclude it. And let me tell you, if you're excluding a stove, the buyer, as a seller, your buyers aren't going to be super excited about that. They walked into a house with a beautiful stove. They want that stove. Might have been why they bought the house, okay? So don't try to over-exclude things. Now, if they have custom curtains made, you might as well leave them there. They're not going to fit their next house. But if they just bought some curtains that they don't want to lose because they like them and they match all their furniture, exclude the curtains. You see how that works? Okay?
If your clients have a family heirloom chandelier in the dining room, tell them to go ahead and take it down.
Take it down before you show.
Put up another one so there's no fight later. Tell them whatever you want in this house needs to go ahead and be packed. The garage door openers, I always check the seller's disclosure to match it up. If I go to title and there's one garage door opener, I go back to the seller disclosure. When I go down where it says garage door openers and it says 3, I expect 2 more at closing. And if they're not there, why is there garage door openers floating around the city? They need to give them to you. So whatever's on that seller's disclosure better match up to what you get at the closing table.
So
Okay.
if your sellers say they lost, don't let them skip that section, because some agents are really picky about the garage door openers, okay?
I mean, I've gone to Home Depot and bought them myself and programmed them myself just to show up at closing with them.
Mhm.
No point in fighting. There's so much other stuff to worry about on closing day. Garage door openers is not one of them.
Awesome. All right, moving on. Exclusions. Okay, so this is where you're going to exclude anything in the property that they want to keep that they were unable to pack. Okay, the following improvements and accessories will be retained by the seller and must be removed prior to delivery of possession, which means before closing and funding. Okay. So again, with the chandelier that's an heirloom, if it's not able to be moved prior to closing, because you know everything needs to be out of the house, it's just that big or it's that delicate that you need, you know, to be careful with it, and they want to wait till everything else is moved out, just make sure you exclude that here. Again, curtains that match their furniture, shrubbery, like if they planted a tree when their baby was born and they want to take that tree with them, they need to exclude it. Okay, otherwise it conveys the property.
You're gonna find that in the listing. Cause you're not gonna know, cause you're not gonna call the seller up and say, what do you wanna take with you when you're writing the offer? So you look at the exclusions in that middle paragraph in the MLS, and that's where you'll find that information.
You can exclude pieces of land, like trees.
You can, but you need to be very detailed about it. As a seller, you can basically exclude anything from the home that you want to, that you can take.
Everything's negotiable.
Everything is negotiable. But yeah, exclusions are listed in MLS. If they're not listed as a buyer and you list nothing and they and they sign it, you get everything. And if they're like, that chandelier was an heirloom, your buyer could be like, I don't care, I bought this house for it. You know, that's the seller's fault for not doing their due diligence. Guys, there's two sides to everything, okay? Make sure that most of the time when you're writing this contract, you're representing the buyer, okay? But as a seller, when we go over seller listing agreements and putting everything into MLS, we'll talk really in detail how to, you know, what you need to say to your clients. But I really want to get through this within the, you know, hour and a half that we have, so we're going to kind of not get too stuck on the sales stuff, okay? Reservations, paragraph E. Any reservations for oil, gas, or other materials or minerals like water, timber, or other interests is made in accordance with the attached addendum. This contract does not state anything about keeping your oil rights or your mineral rights. If your client wants to do that as a seller or as a buyer, they have to do it through the addendum that would be attached, okay? Keep in mind that most people don't even own these rights. So anybody who's getting real picky about it, make sure that they do their due diligence to find out who actually owns those rights in the first place. You're buying a new build, the developer's not giving up the mineral rights. If you bought a property that was built in the early 2000s, that developer didn't give up the mineral rights. So the sellers don't even own them anyways, okay? Just keep that in mind. If somebody's like, I'm only buying this property because I want the mineral rights in Texas, you know, California guy, you need to let them know that they've got to do some serious due diligence about mineral rights, because it's likely that nobody even owns them at this point. You know, it might have been the person who bought it, the land originally. Okay, moving on, paragraph 3, sales price. The cash portion of this of the sales price payable by buyer at closing is the cash price. Section A here is going to be dependent on what the lender tells you that the buyer is putting down as a down payment. Okay, so this part you guys might need to have your calculator out when you're filling it out with your, you know, when you're filling out this contract. If it's a $300,000 home and the lender says they're putting 5% down, you need to figure out what 5% is and put that in here. If they're putting 17.27% down, you need to figure out what that is. If they say, oh, we're just putting $27,000 down, that's what we have, then you put $27,000 here. So it may come to you in different ways, but just make sure that you know that's the down payment. Okay, section B, sum of all financing described in the attached. Is it a third party addendum, a loan assumption addendum, a seller financing addendum? Most of the time you guys are going to have a third party financing addendum, which we will go over today. But make sure that you check one of these boxes if there is financing, okay? A loan assumption addendum is if the seller is keeping the loan and your buyer is just assuming their position in the loan. It's not done very often because mortgage companies don't really allow it, but sometimes they will. So with extenuating circumstances. And a lot of times that's used in case they had like a fantastic interest rate. Somebody bought a house in 2020 and their interest rate's 2.8, and then all of a sudden it's 2024 and interest rates are 11%. Of course you would want to assume that loan rather than trying to get your own because, interest rate is way better. And then seller financing addendum would be just that. The seller owns the home outright and they are financing and holding the note, okay? Third-party financing addendum, though, is usually what you'll check, and then you'll put the remaining amount. So if the home was $300,000, they said they were putting $20,000 down, then you need to figure out, what's the remaining amount. So you put $280,000 there. And that next blank, when you're on zip forms, it stays blank. I mean, you can't fill it out because it adds these two numbers up for you. So just make sure that you are making sure that that's the price, the sales price, sum of A and B. So item C is the sales price, the sum of A and B, okay? If your customers are paying 100% cash, like they're just buying the house cash, they have $300,000, in A, you're gonna put $300,000 and that'll populate your, section C. Moving on, license holder disclosure. Texas law requires a real estate license holder who's a party to the transaction or acting on behalf of a spouse, child, parent, business entity in which the license holder owns more than 10%, or a trust for which the license holder acts as a trustee, or of which the license holder or license holder's spouse, parent, or child is a beneficiary, to notify the other party in writing before entering into the contract of sale. Disclose if applicable. I know that sounds confusing, but basically this is saying, are you buying this house for you, for your parent, or for your child? Are you representing your parent, your child, or yourself? If you are, you'll disclose in this paragraph. Okay? And if you're selling, same thing, guys, make sure that you always disclosing. Even if it's I own 10% of 123 LLC home holdings, then you need to disclose that you own at least 10% of that company. Okay? So disclose. If you're representing a house that you have any interest in, you need to disclose, okay? It does only say parent, spouse, or child. I did one for my aunt and I still disclosed it. Okay, so you don't have to disclose aunts, cousins, brothers, sisters, but honestly, why not? It's better for you to disclose if you have any relation to the person that you're representing than to not and worry if there was a conflict of interest. Okay.
So as a home buyer, we just need to put home buyer is a Texas real estate
License holder. Yep. That's it. It doesn't have to be like super professional. You can be, buyer is a license holder. Seller is a license holder. Buyers representing a parent of a license holder. Agent is related to buyer. Like literally can write anything in there, just make sure you're disclosing what it is, okay? And it needs to make sense, so make sure it makes sense. Paragraph 5, earnest money. Within 3 days after the effective date, buyer must deliver blank as earnest money. Blank is gonna be your earnest money. This is what's gonna go sit at the title company. Usually, not standard, not required, usually earnest money is 1% of the sales price, okay? It can be more. It just shows that your buyer is more committed to the property. They're willing to lose more because they really want the home. It could be less. Everything's negotiable. Usually, this is 1%. So that contract is $300,000. You're going to see $3,000 as earnest money to blank. That blank is your title company, okay? You can put the title company name there. Reason being is title agents, just like realtors, just like lenders, jump ship a lot. If you put a name there, you have to amend the whole contract. So I highly suggest putting just a company name and not an agent name.
And make sure you explain to your buyers that check is gonna be cashed that day.
Will
Don't
be
write
cashed
this,
immediately.
expect to be, I'm getting paid a week from Friday. Don't do it and bail your cousin out of jail. They're gonna cash the check and you're gonna lose the house if they insufficient funds. And it happens way more than you think of people thinking, they won't cash a check for a week or two, I'm good to go. No, you're not.
Same day.
It's cashed immediately.
Just tell them same day, it might be the next day or the day after, but just tell them the same day.
If somebody's buying a house, guys, you need to educate them on how much money they need to have in the bank today. Okay?
In 3 days, title companies are not open on weekends. So if your third day falls on Saturday, it's due Monday. And don't show up the title company Saturday morning at 10 o'clock, you'll be the only one there.
Nobody's there to take your money. Okay, so you put your 1%, usually 1% that's totally negotiable, as earnest money to title company name as escrow agent. You can put a name there, but guys, it really sucks to amend this at the last minute because somebody quit. At blank address, so that's where you put the title company's address, okay? And put the full address, suite number, city, state, zip code, because this is what the seller uses or you use later when you're going to close with that company. You got to make sure you have the full address. Also, earnest money needs to be delivered to that exact address, okay? Buyer shall deliver additional earnest money of blank. So if they say they're going to deposit 1% now, and then just to show how serious they are, another 1% after option period, they could do that. So it would be 1% within whatever amount of days of the effective date of this contract. Okay, most people, and usually, not standard, but usually, nobody delivers extra earnest money. Okay, so it's going to be like a multiple offer situation. If you have questions about that, please ask me before you fill it in. Okay. If the buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under paragraph 15 or both by providing notice to the buyer before the buyer delivers the earnest money. If the last day to deliver the earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money is extended until the next day that is not a Saturday, Sunday, or legal holiday. Time is of the essence in this paragraph, or for this paragraph. Guys, this paragraph is the only out a seller has to back out of a contract. Buyers are protected 43 times in this contract. A seller's protected once, and this is it.
Literally 43.
Literally 43.
Okay.
Yes.
I know it was a lot.
A buyer is protected 43 times. A seller is protected once. In this paragraph on page 1, it says, if the buyer fails to deliver the earnest money within the time required, the seller may terminate this contract. This is the only place they may terminate. So if the money is due on a Saturday, you have legally, according to this contract, till Monday. But this is the only seller's out. So if they got a better offer, do you want to risk it? Deliver that earnest money, guys. Get it there, okay? Time is of the essence in this paragraph because this is where the seller can back out. Okay, title policy and survey. Moving on. A, title policy. Seller shall furnish to buyer at, you have to check one of these boxes, either the seller's expense or the buyer's expense. An owner policy of title insurance issued by your title company can be listed here again. Okay. So who's going to pay for the title? Usually, not standard, not always, usually the seller pays for that. If you're in multiple offer situation, if you are maybe coming in with a lower offer, but they're willing to pay their own title policy, you may check buyer's expense. But usually, not standard, everything's negotiable, you're going to check the sellers are going to pay, and it's issued by whatever title company you guys are closing with. So the title company listed in paragraph 5. Okay? In the amount of the sales price dated at or after closing, insuring buyer against loss under the provision of the title policy, subject to promulgated exclusions, including existing building and zoning ordinances, and the following exceptions. Restrictive covenants common to platted subdivision in which the property is located, the standard printed exception for standby fees, taxes, and assessments, liens created as part of the financing described in paragraph 3, utility easements created by the dedication deed or a plat of the subdivision in which the property is located, reservations or exemptions otherwise permitted by this contract or as may be approved by buyers in writing, the standard printed exception as the marshal rights, the standard printed exception as to waters, tidelands, beaches, streams, and related matters, the standard printed exception as the discrepancies, conflicts, shortages in the area, or boundary lines, encroachments, or protrusions, or other overlapping improvements. Okay, I'm going to stop there for just a second. Go ahead, Kyle.
What's an overlapping improvement?
An overlapping improvement would be like, here's a house, here's a land, and there's a fence that goes this way. The fence would be the improvement. It's overlapping multiple properties. Okay.
Would it
And
also
maybe
be-
it's like a city wall that like goes all the way across because there's a major road on the other side.
Okay.
That would be considered an overlapping improvement.
Would that be also that the neighbor conveniently kind of pushed his property over?
No, because this is talking about title. This is talking about what the title policy is going to protect you against and what it's not going to protect you against. So these 1, 2, 3, 4, 5, 6, 7, 8 are the exceptions to what the title policy will cover. Okay. So what title policy is really doing is protecting you if somebody 3 owners ago had a contractor's lien and it never showed up, and all of a sudden it shows up again. Okay, so that, because that's not a clear title, they had a contractor's lien on that title, which means they could foreclose on the property. This title company didn't catch it, and 3 other title companies didn't catch it, and all of a sudden it pops up. It's just gonna be paid and you're safe. You get to keep your property. Okay, this does not protect you against utility easements, because cities can move utilities if they have to. It doesn't protect you against martial law, which is, again, the same thing. If a city needs to take over your property because of, if the tidelands or water, if you're next to water, if the water moves up, that becomes the lake and is no longer your property. Okay? This is what title insurance will protect you against and what it will not. Okay, so 1, 2, 3, 4, 5, 6, 7, 8 are exceptions to what title will protect you from. So they're not going to protect you from these things. And then number 8, the standard printed exception as discrepancies, conflicts, shortages in the area, boundary lines, encroachments or protrusions or overlapping improvements. At this point, because title insurance is not going to protect you, you need to ask your clients, do you want them to just not amend it and delete it from the title policy because they're not going to protect you anyways, or do you want it to amend the title policy to say that there are shortages in the area? And who's going to pay for it if there are shortages in the area? Is it going to be the buyer or the seller?
Can you explain the shortages in area?
It's just this exact same, the standard printage exception to discrepancies. So if a shortage in the area is considered a discrepancy, conflicts, shorter boundary lines than you originally assumed, encroachments, things that come over onto your land, like a big tree, protrusions or something that push into your land, like maybe roots of someone else's tree, and overlapping improvements like city walls and things like that. So would you want to amend your title policy to say that there are shortages in your area? And who's going to pay for that if there are? The seller or the buyer? Most times, if you're in a, most times, not standard, not always, most times if you are in a regular residential neighborhood and this property isn't like brand new or, you know, new plot or plan, or you're not buying multiple acres, you're just going to delete it from the title policy. There's really no point in trying to fight over who's going to pay for those small shortages if they've been that way for so long. Okay. Now, every client is unique and we cater to those unique needs. So if they say, no, absolutely not, I want this protected and I want to know that the shortage is listed, they may need to pay for that themselves. Okay, not many sellers want to pay for those shortages if they're moving out of the house and never cared in the first place. Okay, all right. The exception or exclusion regarding minerals approved by the Texas Department of Insurance. That's also not covered by your title insurance. Okay, moving on. B, commitment. Within 20 days after the title company receives a copy of this contract, seller shall furnish to buyer a commitment of title insurance and at buyer's expense, legal copies of restrictive covenants and documents, evidence, exceptions in the commitment, exemption documents. Other than the standard printed exceptions, seller authorizes the title company to deliver the commitment and exception documents to buyer at buyer's address shown in paragraph 21. If the commitment and exception documents are not delivered to the buyer within the specific time for delivery, they will automatically be extended up to 15 days or 3 days before closing, whichever is earlier. If the commitment and exception documents are not delivered within the time frame, the buyer may terminate the contract and the earnest money will be refunded to the buyer. So this all talks about the title commitment. You'll notice that over and over again they get extensions because that's the title company's job, but they're never going to be held liable for this contract. So that's why it reads like that. All right, C, survey. The survey must be made by a registered professional land surveyor acceptable to the title company and the buyer's lender. Okay, so the surveyor cannot just be, well, my friend took his survey license, I'm selling the house. It has to be somebody who's approved by the title company and the buyer's lender. All right, part 1. You have to check one of these boxes and pay attention to what box you check because there's more boxes if you check box 1, okay? Box number 1, within blank days of the effective day of the contract, seller shall furnish to buyer and title company seller's existing survey of the property and the residential real property affidavit promulgated by the Texas Department of Insurance, the T-47 affidavit. If a seller fails to furnish the existing survey or affidavit within the time described, the buyer shall obtain a new survey at the seller's expense no later than 3 days prior to closing date. If the existing survey or affidavit is not acceptable to the title company or the buyer's lender, buyer shall obtain a new survey at the seller's expense or the buyer's expense no later than 3 days prior to closing. So a lot of times you're going to check box 1 because most sellers do have a copy of their survey. And you want to give them enough time to find it as a seller's agent. Hopefully they did their due diligence and already uploaded that into MLS for you. And if that's the case, just put 3 days. You want to give yourself a little bit of time to look it over and make sure everything's acceptable. But if it's not listed, give them like 5 days to get that over to you, 7 days. Sellers are doing a lot, right? They're moving, they're cleaning, they're still working. So just be reasonable in your amount of days. But again, everything's negotiable. If they say, hey, we have our survey, we definitely don't know where it's at. Could you please give us 10 days? We've been looking for it and I've got, 27 years worth of files to go through because we've lived here our whole lives. Okay. It happens. If they say 27 years, you're going to know for sure that they're going to need to buy you a new survey because anything over 20 years is not acceptable to a lender anymore. Okay.
I just had one accepted in 1971.
They're not supposed to. So most lenders are, from what I've heard from my lenders, it's illegal to accept a survey that's over 20 years old. It has to be updated due to some new law.
It had to be readable and it had to still be the company had to still be in business. And
Maybe
that's
if the
big-
company's still in business, that
But if they put in a pool, movements,
anything
like that survey.
that's null and void.
Well, in my case, remember,
Mhm.
we benefited us that we
Mhm.
pulled a new one.
Mhm.
The old one was like somebody took a ruler and draw a whole line. We're talking about 1.2 million, and we did our own survey.
We were able to back out.
And we backed out and took all the money back that we paid.
All right, so yeah, definitely if the survey is old,
Like when those fires
you may want to ask for a new one, but it has to be acceptable by the lender and the title company. Part 2, within blank days after the effective date of this contract, the buyer shall buy a new survey at the buyer's expense. Buyer is deemed to receive the survey on the date of the actual receipt of the date specified in the contract, whichever is earlier. So the seller says in private remarks on MLS, there's no survey, seller's not paying for survey. You already know that going into it, so you might choose option 2, and your buyer's going to have to pay for it. Give them at least 15 days. Okay, surveyors are not an easy supply. They take forever. Okay, so 15 to 21 days is on a usual acceptable number of days for survey. Everything's negotiable. Keep that in mind. Or option 3, within blank days of the effective date of this contract, seller at seller's expense shall furnish a new survey to the buyer. So special provision says there's no survey, seller to provide new survey. That's when you would choose this option. Okay, so. Okay, moving on. Objections. Buyer may object in writing to defects, exceptions, or encumbrances to title disclosed on the survey or other items 6A1 through 7 above disclosed in the commitment, other than items 6A1 through 9 above, or which prohibit the following use or activity, blank. Some people will put like running a business, like if they plan on running a business. If that's not allowed, you want to put that in here, okay? Buyer may object the earlier of the closing date or blank days after the buyer receives the commitment, exception documents, and the survey. So I usually give my people 10 days to 21 days to object. So again, this is negotiable. That's what I put depending on the situation I know that's going on with the property. There is no standard here. Okay, you could put 3 days if the seller wants only 3 days for you to be able to read through all that documentation. But that's not really, to me, that's not a fair number. 10 is at least enough days to go through. I mean, these are big documents. Sometimes the title commitment itself is 50 pages, you know. So make sure that you're giving your buyer, when you're filling this out, an adequate amount of time to read through that documentation. Buyer's failure to object within the time allowed will constitute a waiver of the buyer's right to object. So they need to have enough time to read it and object to it, okay? Except that the requirements in Schedule C of the commitment are not waived by the buyer. Provided seller is not obligated to incur any expense, seller shall cure any timely objections of the buyer or any third-party lender within 15 days after the seller receives the objections. That's considered the cure period. And the closing date will be extended as necessary. If objections are not cured within the cure period, buyer may, by delivering notice to the seller within 5 days after the end of the cure period, terminate this contract and the earnest money will be refunded to the buyer, or waive the objections. If the buyer does not terminate within the time required, buyer shall be deemed to have waived the objections. If the commitment or survey is revised or any new exception documents is delivered, buyer may object to any new matter revealed in the revised commitment or survey or new exemption documents within the same time stated in the paragraph to make objections beginning when the revised commitment, survey, or exception documents is delivered to the buyer. That's a lot about objections, okay? My suggestion is to read this when you have time to yourself, because it makes sense when you read it to yourself in your head. Sometimes when someone's reading it to you, you're like, wait, I didn't understand any of that. But the big thing that you need to pay attention to is what activity is prohibited on the premises, and how many days can the buyer have to object to the commitment, exception documents, and the survey. Okay. But definitely read through all of that, because it gives you a lot of information about cure period. That's 10 days plus the 5 days to object after the cure period. These are dates you guys need to know, especially when something goes wrong in your contract. Okay? Cool. Let's move on. Title notices. Abstract or title policy. Broker advises buyer to have an abstract of title covering the property examined by an attorney of the buyer's selection, or the buyer should be furnished with or obtain a new title policy. If a title policy is furnished, the commitment should be promptly reviewed by an attorney of the buyer's choice due to the time limitations on the buyer's right to object. So that paragraph right above us that gives all those crazy objections, and that's a lot of documents I told you for them to read through. If they do not understand, advise them to seek an attorney's counsel. We are not attorneys. It is not our job to know every single word in those documents, but you should at least be familiar with them. But advise them to seek an attorney's advice just to breeze through those. They only have a certain amount of days, and sometimes they can't read through it and understand it in that allotted time. Okay, number 2, membership in property owners association. The property blank is or blank is not. Pay attention to which one is which. This has happened in our brokerage where someone chose the wrong kind and then didn't even notice that they did it, okay? And an issue arose out of it. So the property either is the first checkbox or is not in an owner's association, homeowners association. If the property is subject to mandatory membership in a property's owners association, seller notifies buyer under paragraph 5.012 Texas Property Code that as a purchaser of the property in the residential community identified in paragraph 2A in which the property is located, you are obligated to be a member of the Property Owners Association. Restrictive covenants governing the use and occupancy of the property and all dedicatory instruments governing the establishment, maintenance, or operation of the residential community have been or will be recorded in the real property records in the county in which the property is located. Properties of the restrictive covenants and dedicatory instrument will be obtained from the county clerk. You are obligated to pay assessments to the Property Owners Association. The amount of the assessments is subject to change. Your failure to pay the assessments can result in enforcement of the association's lien and the foreclosure of the property. Section 207.003 of the Property Code entitles the owner to receive copies of any document that governs the establishment, maintenance, or operation of a subdivision, including, but not limited to, restrictions, bylaws, rules, regulations, and resale certificate from a property's owners association. A resale certificate contains information including, but not limited to, statements specifying the amount and frequency of regular assessments and the style and cause number of lawsuits to which the Property Owners Association is a party, other than lawsuits related to unpaid ad valorem taxes of an individual member of the association. These documents must be made available to you by the Property Owners Association. By the association or the association's agent on your request. So, okay, we're about to go into a page that's a bunch of information. The Owners Association does have an addendum attached to it, so make sure that you are paying attention to all the addendums that you have to do. If you check that this is in an Owners Association, add the addendum. Guys, we're going through every single word of this contract because you need to know these things, okay? If there's an association payment due and for whatever reason they didn't understand, it was your job to make sure they knew every word in this contract that they were signing, okay? Because you're asking them to sign without an attorney, sometimes just on a digital signature. It's good to have a buyer consult to chat with them about what these things mean, okay?
And this is for mandatory membership.
Mandatory
So
membership.
if it says voluntary.
That doesn't count. That's voluntary.
Put it as no.
Oh, no. Yeah, if it's voluntary, you choose no. It is not in a mandatory association.
There are voluntary HOAs.
Mm-hmm. Yeah.
Really? I don't know that.
Most of them, they maintain like lawns, but they don't have insurance, they don't have policies in place, they don't have bylaws, those kind of things. Voluntary ones are not considered a real association. They're usually ran by residents. Okay, so just make sure that you tell your clients if they choose a home that's in a mandatory association and they don't pay that, they could be foreclosed on and lose their property. Okay. Statutory tax districts. If a property is situated in a utility or other statutory created district providing water, sewer, drainage, or flood control facilities and services, Chapter 49, the Texas Water Code, requires the seller to deliver to the buyer to sign the statutory notice related to the tax rate, bonded indebtedness, and standby fee of the district prior to final execution of the contract. Okay, so these are talking about MUDs and PIDs. Okay, so usually any kind of new development that has its own school district and like these big water parks and stuff like that, those usually have a PID or a MUD. Tidewaters. If the property abuts to tidally influenced waters of the state 33.135 Texas National Resource Code requires a notice regarding coastal area property to be included in the contract. An addendum containing the notice promulgated by TREC or required by parties must be used. I'm not going to touch on that too much because we do not have tidewaters here, but we do have lakes, so just keep it in mind. Annexation. So all of this is just informational for your client. They need to know it though. Again, they're signing this contract, okay? Annexation. If the property is located outside the limits of a municipality, seller notifies the buyer under Section 1.011 of the Texas Property Code that the property may now or later be included in an extraterrestrial jurisdiction of a municipality and may now or later be subject to annexation by the municipality. Each municipality maintains a map that depicts its boundaries and extraterrestrial jurisdiction. To determine if the property is located within a municipality's extraterrestrial jurisdiction, try saying that 5 times fast, or is likely to be located within a municipality's extraterrestrial jurisdiction, contact all municipalities located in the general proximity of the property for further information. The property is located in a certified service area of a utility service provider. Notice required by Section 13.257 of the Water Code. The real property described in, sorry, I got a message, in a certified water or sewer service area, which is authorized by the law to provide water or sewer service to the properties in the certified area. If your property is located in a certificated area, there may be special costs or charges that you will be required to pay before you can receive water or sewer service. There may be a period required to construct lines or other facilities necessary to provide water or sewer service to your property. You are advised to determine if the property is in a certificated area and conduct the utility service provider to determine the cost that you will be required to pay and the period, if any, that is required to provide water or sewer service at your property. The undersigned buyer hereby acknowledges receipt of the foregoing notice and at or before the execution of a binding contract for the purchase of real property described in paragraph 2 or at closing of the purchase of real property. Every time it says paragraph 2, they're talking about the legal description of this property. And usually this part is going to be considered if they're buying like way out. It's not really in a city, you know, so there may not be utilities there. You just need to make sure that your buyer knows that nobody's liable for those costs except for them, okay? Public improvement districts. This is a PID here. If the property is in a public improved district, Section 5.04014 Property Code requires the seller to notify the buyer as follows. As a purchaser of this parcel of real property, you are obligated to pay an assessment to the municipality or county for an improvement project undertaken by a public improved district under Chapter 372, the Local Government Code. The assessment may be due annually or in periodic installments. More information concerning the amount of the assessment and the due dates of the assessment may be obtained by the municipality or county levying the assessment. The amount of the assessment is subject to change, and your failure to pay the assessment can result as a lien and foreclosure on the property. So if they do a big project that was voted on by taxes, they have to pay it. Transfer fees. If the property is subject to private transfer fee obligation, Section 5.205 of the Property Code requires the seller to notify the buyer as following. The private transfer fee obligated may be governed by Chapter 5, subchapter G of the Texas Property Code. Number 9, propane gas systems and service areas. If the property is located in a propane gas system service area owned by a distribution system retailer, seller must give buyer written notice as required by section 141.010 of the Texas Utilities Code. An amendment containing the notice approved by TREC or required by the parties should be used. So there's an addendum for propane gas. Not many areas in our area use propane gas, but the seller would know. It would say, and it would also say in the seller's disclosure. So make sure you guys are reading through those if you ever have questions of what kind of property your buyer is buying, okay? Don't just give it to them. You should read it too. All right, number 10, notice of water level fluctuations. If the property adjoins an impoundment of water, including a reservoir, lake constructed and maintained under Chapter 11 Water Code that has a storage capacity of at least 5,000 acre-feet at the impoundment's normal operating level, seller hereby notifies the buyer. The water level of the impoundment of water adjoining the property fluctuates for various reasons, including as a result of an entity lawfully exercising its rights to use the water stored in the impoundment, or drought or flood conditions. So if you guys are next to a lake, this paragraph is the seller's letting the buyer know, okay? There doesn't need to be another document signed. Property condition. A, access, inspections, and utilities. Seller shall permit buyer and buyer's agent to access the property at reasonable times. Buyer may have the property inspected by inspectors selected by the buyer and licensed by TREC, or otherwise permitted by law to make inspections. Any hydrostatic testing must be separately authorized by the seller in writing. Seller at seller's expense shall immediately cause existing utilities to be turned on and shall keep utilities on during the time of the contract is in effect. So if you guys are buying a property that has no electric when you went and looked at it, the seller is required to turn those utilities on for inspection, okay? So if they don't do that, make sure that you exercise your right to let them know they need to. B, seller's disclosure notice pursuant to section 5.008 of the Texas Property Code notice. Check one box only. Either the buyer has received the notice because you saw it in MLS, or they emailed it to you after you told them you were putting an offer in, or any time. And even if it was only sent to you, the buyer is assumed to have received it, okay? So the buyer has received the notice, or the buyer has not received the notice. And within, I usually put, not always, not standard, usually put 3 days of the effective date of this contract, the seller shall deliver the notice to the buyer. If the buyer does not receive the notice, the buyer may terminate this contract at any time prior to the closing, and the earnest money will be refunded to the buyer. The seller delivers the notice, buyer may terminate this contract for any reason within 7 days after the buyer receives the notice or prior to closing, whichever occurs first. The earnest money will be refunded to the buyer. Okay, so with this number 2, if you check number 2 and give them 3 days, but you only have a 5-day option period, you're screwing your client, okay? Make sure that your option period days and your seller's disclosure days match up accordingly. If you're only having a 5-day option because it was really high, competitive thing, and that's how you used to be competitive because your inspector's awesome and you're going to get them in the next day and have that inspection report the same day, you need to have the seller's disclosure prior to inspection, because you want to look at that and be like, oh, they've had water damage. And Mr. Inspector, can you please check and see if you see any other water damage? They've had, broken windows. Can you tell me how many broken windows there are and about how much you think it might be to fix it? Whatever questions your buyers might have, you want to make sure those two things coincide so that you can effectively negotiate for your client during that option period, okay? So don't give them 15 to 20 days here. It doesn't make any sense. They should have that filled out prior to listing, okay? If you have a 10-day option, 3 days is adequate. But you want to make sure, again, that you have that prior to your inspector coming in. Or number 3, the seller is not required to furnish the notice under the property code. So there's a couple of reasons why a seller doesn't have to give you a seller's disclosure. One is the property is inherited. They've never lived in the property, okay? But anybody who's purchased the property, just because they didn't live in it doesn't mean they don't have information to disclose on it. And you guys, we just had this seller's disclosure class CE with Sean. almost always they should have it. Okay. Section C, seller's disclosure of lead-based paint and lead-based paint hazards is required by federal law for a residential dwelling constructed prior to 1978. That was on everybody's test, so I hope you remember that year. If that Section C, if the home is built prior to 1978, you do have to do a lead-based paint addendum. Acceptance of property condition as is means the present condition of the property with any and all defects and without warranty except for the warranties of the title and the warranties of this contract. The buyer agrees to accept the property as is under paragraph 7D 1 or 2. Does not preclude buyer from inspecting the property under paragraph 7A, from negotiating repairs or treatments in a subsequent amendment, or from terminating this contract during the option period, if any. You guys hear what that said? Basically, it says they can accept the property as is today and amend that paragraph later, okay? And this is where our amendments usually come in. We'll go over that in a bit. All right, so either they check number 1, buyer accepts the property as is, or number 2, the buyer accepts the property, and they already saw something huge, like 3 broken windows, and that's all they want fixed. I'm pretty sure I just want the 3 broken windows fixed. So they are already going to list that. And there can be an inspection period, and they can add more. But I usually, not always, this is negotiable, check buyer accepts property as is, because we don't know what else might come up. Windows might be nothing compared to foundation if you find out there's a foundation issue later, okay? Section E, lender required repairs and treatments. Unless otherwise agreed in writing, neither party is obligated to pay for lender required repairs, which includes treatment of wood destroying insects. If the parties do not agree to pay for the lender required repairs or treatments, this contract will terminate and the earnest money will be refunded to the buyer. If the cost of the lender required repairs and treatments exceeds 5% of the sales price, buyer may terminate the contract and the earnest money will be refunded to the buyer. Nobody has to do repairs, okay? Completion of repairs and treatments. Unless otherwise agreed in writing, seller shall complete all agreed repairs and treatments prior to the closing date. And all required permits must be obtained, and repairs and treatments must be performed by persons who are licensed to provide such repairs or treatments. Or, if no license is required by law, are commercially engaged in the trade of providing such repairs or treatments. Meaning, don't have your husband fix something or your wife fix something just because she knows how to do it, okay? If it's not their standard job, then they don't qualify. At the buyer's election of any transferable warranties received by the seller with respect to the repairs and treatments will be transferred to the buyer at buyer's expense. If seller fails to complete any agreed repairs and treatments prior to the closing date, buyer may exercise remedies under paragraph 15 or extend the closing date up to 5 days if necessary for the seller to complete the repairs and treatments. Okay, so those need to be done before closing. Environmental matters, buyers advise the presence of wetlands, toxic substances, including asbestos and wastes or other environmental hazards, or the presence of threatened or endangered species or its habitat may affect the buyer's intended use of the property. If a buyer is concerned about these matters, an addendum promulgated by TREC or required by the parties should be used. So if you think that there's something, wetlands or anything like that, make sure you jump into zip forms because they have addendums for that. Residential service contracts talks about the, like a homeowner's warranty. So what Christine does, Nation's Home Warranty, okay? The buyer may purchase a residential service contract from a residential services company licensed by TREC. If the buyer purchases a contract, the seller shall reimburse the buyer at closing for the cost of the residential service contract in the amount not to exceed. Pick a number. Talk to your title person or your warranty person and ask them. Usually I put 600. If there's a pool or really steep roof or water heater in the ceiling, up in the attic, you might need to go a little bit more, but ask your preferred person of what a standard number is. A normal number, nothing is standard, everything's negotiable.
And they're allowing money now because the buyer has to pay a service call. It's usually $75. So now they're doing like 2 free service calls in it. So if it's agreed upon, throw in, if that's the title or your warranty company allows you, put in another $150 to pay for the first 2 service calls.
Yeah.
But check that amount, because sometimes I've seen, $1,000, it's like, you can't use $1,000. I'm not paying for
You're
5
basically
years.
paying, yeah.
Donations does the first one free, I think.
Awesome. Okay, so broker's fees. All obligations of the parties for payment of broker's fees are contained in a separate written agreement. That means if you don't have a buyer rep agreement prior to signing this contract, they are not obligated to pay you. So get your buyer's reps signed, listing agreements as well. Okay, closing. The closing of the sale of the will occur on or before blank date, list a date, or within 7 days after objections are made under paragraph 6D have been cured or waived. Whichever date is later is going to be the closing date. If either party fails to close the sale by the closing date, the non-defaulting party may exercise remedies contained in paragraph 15. Okay. At closing, the seller shall execute and deliver a general warranty deed conveying title to the property to the buyer and showing no additional exceptions to those permitted in paragraph 6, and furnish tax statements and certificates showing no delinquent taxes on the property. Buyer shall pay the sales price in good funds acceptable to the escrow agent. Seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, release, loan documents, and other documents reasonably required for the closing and the sale of the insurance of the title policy. There will be no liens, assessments, or security interests against the property which will not be satisfied out of the sale proceeds unless secured the payment of any loans assumed by the buyer, and assumed loans will not be in default. If the property is subject to a residential lease, seller shall transfer security deposits as defined under section 92.102 of the property code, if any, to the buyer. In such an event, buyer shall deliver to the tenant a signed statement acknowledging that the buyer has acquired the property and is responsible for the return of security deposits, and specifying exact dollar amounts. This is only if the property is an investment property.
And make sure you look at your calendar. Look like you know what you're doing. Don't just go 30 days. You don't want to put on there weekends, federal holidays. Tuesday through Thursday is the best for title companies, but if it has to be Friday, put Friday, but don't put on there Sunday, Easter.
She's
Christmas
talking
Day.
about the closing date. Make sure you're paying attention to what closing date you're putting in there.
Get out your calendar and check. Make sure that it
Because
falls
then you
on a
have
day.
to amend it. You don't want to amend a closing date.
Friday the 13th.
See, that's fine, title company's open, but if it would have been Columbus Day, you wouldn't have been able to close on Columbus Day. Because title companies have closed all federal holidays too.
All right, guys, we have a lot to go through in 10 minutes, so I'm going to start skipping through some stuff, okay? Possession, the buyer possession. They're either going to take possession upon closing and funding, which is when the property closes and all funds are dispersed, or according to a temporary residential leaseback, which means the seller could lease back the property or the buyer can lease the property prior to closing and funding, okay? Special provisions. Only insert factual statements here. So the seller to professionally clean the property, you might put something there, or anything else that's a factual statement. Do not practice law. Do not write crazy exemptions in here, okay? Facts only. Settlement expenses. The following expenses must be paid or prior to closing. Expenses payable by the seller. Release of existing liens, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, preparations of the deed, or 1/2 escrow fee, and the expenses payable by the seller under the contract. Section B, seller shall also pay an amount not to exceed blank to be applied to the following order: the buyer's expenses which buyer is prohibited from paying by VA, FHA, Veterans Land Board, or other government loans, and then to other buyer's expenses that are allowed by the lender. This is if the seller is giving a concession. If you ever hear that word, a seller's concession, it means the seller is paying for some of the fees that the buyer has to pay. So you might see in here, there is no standard, there is no normal, this is, right now it's a seller's market, so you're usually gonna see 0 here because you're not gonna be competitive if you're asking for, $5,000 in closing costs. But anything can go here, up to what the lender says that they're allowed to get back in credits. And I think it's like 6%, up to 6% of the loan on FHA and VA. So if it exceeds 6% of the loan, so if the loan's 100,000, you can't put more than 6,000 here because they're not allowed to get that much credit from someone else. They have to have money of their own to buy a house. Okay. Expenses payable by the buyer, they have to get their own appraisal fee. We're in section 2 of this same paragraph. They have to do their own inspection. They have to take their own photos. They have to be responsible for the amortization schedule, basically all their payments. And then it also goes through everything that they're going to pay. Pay attention to this paragraph. I'm not going to read it all to you because we need to get going, but pay attention to this because this is what the buyer has to pay at closing. Okay? And what they are responsible for after. Prorations. Taxes are prorated. So if you buy a house on October 1st, you're only going to pay as a buyer taxes from October, November, December. But the seller already paid the taxes. Taxes are paid at the beginning of the year based on last year's tax numbers, okay? So the seller paid in January for the whole year of taxes. So what you'll see on a HUD is, or a closing disclosure now, is that there's a credit to the seller and a debit to the buyer. So don't let that confuse you, okay? They're crediting the seller because the seller's already paid the taxes. Casualty and loss, that just talks about insurance. Make sure that they have insurance. Default, if the buyer fails to comply with this contract, the buyer will be in default. And the seller may enforce specific performance, seek such other relief as may be provided by law, or both, and terminate this contract and receive the earnest money and liquidated damages, thereby releasing both parties from this contract. If the seller fails to comply with the contract, the seller will be in default and the buyer may enforce specific performance, seek such other relief as may be provided by law, or both, and terminate this contract, receive their earnest money, thereby releasing both parties of this contract. Okay, this is where an attorney might get involved if somebody defaults on the contract. Mediation. Paragraph 16 states that you will try to mediate prior to going straight to mediate a dispute rather than going straight to an attorney. Attorney's fees. A buyer is responsible for their own. A seller is responsible for their own unless there is a default in contract. Escrow. Escrow talks about this contract does not have liability for performance or non-performance of any party of the contract liable. So the escrow agents are not. Title is not involved in this. You notice they have lots of outs. Expenses. At closing, the earnest money may be applied first to any cash or down payment, then to the buyer's expenses. So this talks about how your money is applied, and so that's why title does what it does, okay? Demand. Guys, read through this when we're done, okay? Because this is really good information. Demand. Upon the termination of the contract, either party of the escrow agent may send a release of earnest money to each party, and the parties shall execute counterparts of the release and deliver same to the escrow agent. If the party fails to execute the release of earnest money, either party may make a written demand to the escrow agent for the earnest money. Okay, so if you guys are having a dispute of who gets the earnest money, as long as it makes sense in the contract, and there's an out in the contract, the title company can release the earnest money. This happened to Nadeem with a contract that he had. Because of our release in the contract due to an objection, they didn't even have to get a signature. We were able to require them to just release. Okay.
The seller did send me 2 days ago, the form
Oh, go figure. Damages. Damages talks about, if you do go into a lawsuit, the losing party has to pay for your damages and your attorney's fees, notices. Escrow agents will notice. Notices will be effective when sent in compliance with paragraph 21. Notice of objection to the demand will be deemed effective upon the receipt by the escrow agent, okay? So it just means that, like, if you send something to title, as soon as it's sent, it's considered received, and if something is sent to you, as soon as you get it, it's considered received. So make sure you're sharing your emails with your clients. Representations. All covenants, representations, and warranties in this contract survive closing. Okay, so just because we closed doesn't mean your buyer, if your seller said they're going to fix something, just because you closed and they patched it up, doesn't mean that they're free and clear of that. They'd still have to fix it, okay? federal tax requirements. If anybody's a foreign person, that has to be specified in a foreign person affidavit. This is just to make sure that taxes are done correctly if somebody has accounts in another country. Notices. Guys, this notices paragraph 21 was mentioned multiple times in the contract. If you are the buyer, you need to put the buyer's name, their phone number, their email. Okay, and I always, on this really long line, the second long line, I always put my email, CC Renee at sagestreetrealty.com, because I want to know what they're seeing. If I don't know and they send me a question, I'm like, I have no idea what you're talking about. Then I look stupid. So it's best if you just CC yourself, make sure their information is correct so title can reach out to them. But anytime title emails something, they'll copy you into it because it's required according to the contract. Okay, also be careful with that, because if you're CC'd, they didn't see it and you saw it, you need to make sure that you're re-forwarding it or calling them and saying, hey, did you get that last document that came in? Make sure you read through it and let me know if you have any questions. Simple as that. If you can't answer their questions, don't worry about it. Call your title company, ask the question, and then reply the answer, okay? Sellers should do the same. Agreement to parties, if you have any addendums, so third-party financing addendum, seller financing, addendum to subject to property and owners association, buyer residential lease, loan assumption, addendum for sale of other property. That means they have to sell their house before they can buy this house if they want to reserve the gas and oil or mineral rights. If this is a backup contract and not a real contract, if you're living in a coastal area, if they're doing a hydrostatic test, if they are addendum concerning the right to terminate due to the lender's appraisal, environmental threatenings addendum, the seller's residential lease back, short sale addendum. We don't have many of those, but they come up occasionally. Gulf intercoastal waterway, we won't ever fill that out. Addendum for seller's disclosure of lead-based paint, addendum for property and propane gas service area, or anything else that you addendum to this contract. So if you made an attachment or anything like that, make sure you click on other, or if there's any other addenda that came up that you needed to attach, okay? These are just the standard ones in paragraph 22. Paragraph 23 is the termination of the option period, or termination options. So you guys have a certain amount of days for normal consideration, the receipt of which is hereby acknowledged by the seller, and buyer's agreement to pay a standard amount, not required, not always, not usual, but is about $100. Some people will go way more than that. If it's a high competitive, you might want to put $500. If the house is $1 million house, don't put $100 option fee. That is ridiculous. Okay. Think about like 0.1% is usually somewhat standard. So, okay, there is no standard though. That is fully negotiable, but be reasonable. If your buyer can back out for any reason, so this is the seller's only protection here, if your buyer backs out and they took that house off the market, okay? So make your client stand out and put a reasonable number there. They have how many days to be in that option period. So if you're asking for 15 days, that option money probably needs to reflect 15 days, okay? But this gives you the right to back out of the contract unrestrictedly. So there's no reason, they still get their earnest money back for whatever reason they back out. They woke up and sneezed and thought it was an omen and they don't want to buy the house anymore. They get to back out and they get their earnest money back. The inspection came back and the house is like literally falling apart and they're like, holy crap, I don't want to buy this house. They get to back out and they don't lose their earnest money, okay? And then at the bottom of this paragraph, the option fee will be or will not be credited to the sales price. Also, time is of the essence for this paragraph, and strict compliance with the time for performance is required. If you do not back out by 5 p.m. on the date that your option ends, your client loses their earnest money if they back out, okay? That's your fault for not paying attention to the days. When Adrian said to make sure that you're paying attention to dates, counting days, looking at your calendar, this applies, okay? If option ends on a Sunday, option ends on a Sunday. It's not business days, it's calendar days. So make sure that it's something that you can still manage. Paragraph 24, consult an attorney before signing. You've already asked them to consult the attorney multiple times, but if they want to, you need to have their buyer's attorney information here so that everybody's got a copy of that. Executed. Okay, so this box here, executed the blank day of blank, comma, blank effective date. The broker to fill in the final acceptance. That does not mean me. I do not need to fill in your executed date, okay? I have given you the right as a licensed agent with Sage Street Realty to fill that date in, okay? What that means is the last person to sign. So if you submit this contract as a buyer, your buyer signs. Do not fill in the execution date. It may not be the execution date. The seller might not accept this contract for 3 or 4 or 5 days afterwards, okay? So the last person to sign, if the seller signs the next day and they didn't object to anything in your contract, then they can execute. But let's just say they said, okay, I don't want to give you 10 days, I only want to give you 7 days in your option period. They might put a little line through your 10 and put a 7 and initial it. Then they are not the last person to sign either. Your client will then be the last person to initial that paragraph. You see how that works? The last signature. Like, I hope that you guys are talking to the seller's agent or vice versa. Hey, we want you to change this date and resubmit the contract, because you want to have as clean a contract as possible. But if it's something small like that, sometimes people will just go ahead and update it and get it signed so we can execute as fast as possible. But the last signature is the one to date this contract. You as agents have the authority to execute the contract. Okay, moving on. The next page is page 9, broker information. Other broker is the buyer. Listing broker is the seller. If the seller's broker, okay, so let's just say Adrian has a listing. The listing broker is going to say Sage Street Realty. Then Adrian let Candy do her open house, and Candy finds a buyer. So now Candy's the buyer's agent. Candy, you will not be other broker firm. You will fill out, if you scroll to the bottom of that page, the bottom of the section where it says listing broker, right under that it says selling associate's name. You guys are both the same broker. You're both with Sage Street Realty. So a listing associate name would be Adrian. Selling associate name would be Candy. Okay? So if you're doing intermediary, make sure that you fill this out correctly. Okay? The title company doesn't need to see Sage Street Realty, Sage Street Realty. Okay? Unless you're you're Sage Street Realty and they're Keller Williams. That's how you're going to fill those two separately out. Listing broker, the bottom little area right here, listing broker agrees to pay other broker blank amount of the sales price. Usually it's going to be 3%. Everything's negotiable. Just because they don't fill this out doesn't mean you don't have to pay them. That agreement is made in MLS, okay? So regardless if that's filled out or not, it has to be done. And then the very, very last page is our option receipt page. Make sure that if you take the option money yourself, you sign that. And make sure that the title company signs the earnest money receipt. I need both of these uploaded. If they're on separate pages, that's fine. Upload both of them when it comes to that in back agent. Okay? All right, let's move on. Quickly, because I want to just breeze through these other contracts. We are 10 minutes over almost. All right, third-party financing addendum. The first line is the street address and the city. Okay? Make sure you're putting an address there. The type of financing and duty to apply and obtain approval. Buyers shall apply promptly for all financing described below and make every reasonable effort to obtain approval for the financing, including but not limited to furnishing all information and documents required by the buyer's lender. So your buyer can't be like, oh, I want to buy this house, and then never go get a loan until the last minute. Oh, we can't buy it because we didn't get it approved in time. Okay, this is saying that they're making every effort to do so. Is it a conventional loan? If it is, you're going to choose number A or section A. Number 1 talks about the mortgage loan. The first box is how much they are financing, not the price of the home. Okay, so $300,000 home, they put $20,000 down. You're going to put $280,000 here. Okay. Excluding any finance PMI, so we're not going to worry about PMI here. It's just basic numbers. Due in full in 30 years unless they're getting a 15-year note. Ask their lender. With interest not to exceed, give a reasonable number. If interest right now is at 2.8%, put 3, okay? It needs to be reasonable. They might not be able to qualify for the lowest interest rate today. Per annum for the first, probably going to be 30 years, but if you said they're doing a 15-year, then you need to put 15 years here, okay? With the origination charges as shown on the buyer's loan estimate for the loan not to exceed, that's the total price, or sorry, percent of the loan. So percentage, the buyer's estimate usually says not to exceed 2% of the loan. That's normal, but ask the lender if you don't know or if their loan estimate that they received is more. Okay? If they're getting a second mortgage as well, you would also check number 2 and fill that out. Most people won't get a second mortgage. Texas Veterans Loan, this is a VA, this is a Texas VA loan. So this is where you would fill out the land and board amount and the period that they're gonna get their loan for. FHA, FHA is a 203B. That's the type of FHA loan that's being given out right now. Insured loan for not less than, so you're going to put your financed amount here. So they usually put 3.5% down for an FHA loan, so you need to figure out what 3.5% is of the sales price. Amortized monthly for not less than, it's always going to be 30 years. You cannot do a 15-year FHA loan. With interest not to exceed blank per annum. Again, that's usually 2%. Check with the lender. It may change. For the first 30 years of the loan, the origination charges is shown on the buyer's loan estimate not to exceed. I'm sorry, interest rate up here is not 2%. Whatever the interest rate is, ask what their interest rate is. And then this last box here is not to exceed 2% of the loan. Okay, VA guaranteed financing. So regular veterans loan is going to be section D. Okay, so you're going to fill, all of these are filled out the same way. The amount of financing, how many years their loan is for, their interest rate, and the percentage of the loan that they cannot exceed, which just check their loan estimate. They should already have one, okay? They should have one prior to you offering. Don't go offering on properties when someone hasn't even talked to a lender yet, okay? USDA guaranteed financing. These are very specific loans. You have to be certain cities and they have to qualify for this type of loan, but you fill it out the same way. Reverse mortgage financing. This is usually for senior citizens where they, have put so much money into their home, and so now rather than making a mortgage payment, they're doing a reverse mortgage, so they're taking some of their equity out. Get with the lender. If you're doing a reverse mortgage, make sure you understand it because there is a lot to that loan. Number 2, approval for financing. Approval for financing described above will be deemed to have been obtained when the buyer approval and the property approval are obtained. Time is of the essence in this paragraph, and strict compliance with the time for performance is required. Meaning, if you go over the date, you don't get no takebacks. You have to extend those dates prior to, okay? Section A, buyer approval. This contract is subject to the buyer. Always check this box unless your buyer is doing cash. I mean, obviously you're not going to do this, but if they're like all the way approved, you might want to waive this, but I would say never waive it. Just check the box. This contract is subject to the buyer obtaining buyer approval. If the buyer cannot obtain buyer approval, buyer may give written notice to seller within blank days of the effective date of this contract, and the contract will be terminated and the earnest money will be refunded to the buyer. If the buyer does not terminate the contract under this provision, the contract shall no longer be subject to the buyer obtaining buyer approval. Buyer approval will be deemed to have been obtained when the terms of the loan are described above are available and the lender determines that the buyer has been satisfied all the lender requirements required to the buyer's assets, income, and credit history. Assets, income, and credit history. This paragraph says nothing about the appraisal because the appraisal approves the property, not the buyer. You see how there's a difference there? There's 2 parts of approval, the buyer and the property. So section A talks about the buyer's approval, assets, income, and credit history. So that blank box there gives them a certain amount of days to get approved. They should have already been giving their information to the lender, so usually anywhere between 15 to 20 days is standard, but negotiable. Some sellers don't want to give them that much time, okay? And then part 2 says this, the second checkbox, this contract is not subject to buyer obtaining buyer approval. If you check that, they have no out if they can't get approved for lending. They still have to buy the property, which means specific performance hasn't been obtained, okay? Part B, property approval. There's a difference. There's buyer approval and there's property approval. Property approval, if the buyer's lender determines that the property does not satisfy lender's underwriting requirements for the loan, including but not limited to the appraisal, insurability, and lender required repairs, buyer, not later than 3 days before closing date, may terminate this contract by giving the seller notice of termination, a copy of the written statement from the lender stating the fourth reason and the lender's determination. And if the buyer terminates under this contract, the earnest money will be refunded to the buyer. If the buyer does not terminate under this paragraph, property approval is deemed to have been obtained. Okay, so if you give your people 15 days to get approval and they can't get an appraiser there within 15 days, that doesn't matter. You're still protected because you have up until 3 days prior to closing to get an appraisal done, the appraisal back, and all that good stuff, okay? So do make sure that you understand the difference between buyer approval and property approval. Security. Each note of financing described above must be secured by the vendor's deed of trust lien. FHA VA required provision. The property with FHA and VA, because they're government backed, have to appraise for a certain amount. And it has to be the contract price. They cannot appraise for less and then they come out of pocket, okay? Because they're government backed loans. So make sure that you put the sales price in this blank here. That's how much the house has to appraise for. Also be careful what you're offering there. If you're offering, $10,000 over asking and you know it's not going to appraise, if the seller's agent is savvy, they're going to know that doesn't fly. So make sure you're putting in reasonable numbers here. Okay, buyers and sellers have to sign this. Moving on. Addendum for lead-based paint. So, you guys know that if the property is built prior to 1978, we have to talk about lead-based paint. As a seller fills out section B. They either know that there's presence of lead-based paint or they do not know. So, A, they would check, yes, I know, and this is what I know about it. Or they're going to say, no, I have no idea if there's lead-based paint. I moved in here. It was a flipped property. I don't know what you're talking about. Okay. Number 2, records and reports will be available to the seller. The seller has provided the purchaser with available records. So if they knew there was lead-based paint in 1981, it came up, there was a lawsuit, blah, 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 and they have documentation, they need to check box A and give you the documentation, or check box B. I don't have anything. I don't know what you're talking about. Okay. Buyer's rights. So from C and D are filled out by the buyer's agent. Okay, so, or not by the buyer's agent, but by the buyer. So this document is signed by both parties and filled out by both parties. Section B is for the seller, section C and D is for the buyer. Buyer's rights. Do you waive the right to conduct a risk assessment or inspection of the property for lead-based paint? Most of the times, yes, because it's been so long, there's never been anything. But if you want one, then within 10 days of the effective date of this contract, you check section number 2, and they can get a lead-based paint inspector out there, okay? Buyer is acknowledging in section D that the buyer has received copies of information listed above, if the seller had anything to list it in 1 or 2. And then within 10 days, buyer has received a pamphlet, Protect Your Family from Lead in Your Home. That is your job, realtor. Okay, so if it's built before 1978, you just right away go into Zip Forms and pull out the pamphlet. It's called Protect Your Family. You search that in all forms, download it, and email it to your client, okay? Then they've received it, and they can check they've received it. You'll notice at the bottom of this contract, the buyer signs and dates, buyer 2 signs and dates, the seller signs and dates, but both listing brokers sign and date. I do not need to sign this. You have the authorization to sign for me, okay? So both realtors need to sign this document. Moving on. Okay, addendum for property in owners association. Make sure you add the address, the owners association name, whatever the company name is, 123 Association, and their phone number. Okay, so you should have been given that information in MLS. Subdivision information. So how many days does the seller have to get the buyer their information? You're only going to choose 1, 1, 2, 3, or 4 in section A, okay? So is the seller going to buy it? Is the buyer going to buy it? And is it going to be approved? It does or does not require an updated resale certificate. So sometimes if they changed companies or something like that happened, you might need an updated sale certificate. Otherwise, they'll use the one that they already have. Material changes. If there's anything that needs to be changed or talks about bylaws here, fees, there's always a transfer fee for HOA from one person to the next person. So what you're saying is that the buyer is going to pay whatever amount you put in this box. So say you put $150. The buyer is willing to pay $150 to transfer the resale cert. But this particular HOA requires a $350 resale cert. The buyer still is required to pay the $150, and the seller will pay any excess. So if there's more than the $150, seller pays it. If it's less, then the buyer pays it. Okay. And then, let's see, authorization. Seller authorizes the association to release and provide the subdivision information and updated resale cert if requested by the buyer to the title company or any broker to the sale. If the buyer does not require the subdivision information or an updated resale cert and the title company requires information from the association such as status of dues, assessments, etc., the buyer or the seller shall pay the title company the cost of obtaining the property information. So who's going to pay if the title company had to pay? Okay. And then everybody signs there. Okay, it's buyer and seller. Right to terminate. Let's see. So the property listed. So this is due to the lender's appraisal. You put the address here. The financing described in the third-party financing addendum attached to the contract of the sale of the above referenced property does not involve FHA or VA. So you noticed there was that FHA VA provision saying the house has to appraise for this or else you can back out. If you have a conventional loan, you might want to either waive the right to terminate due to the appraisal or do a partial waiver. This is usually used if there's multiple offers on a property where you're waiving the right to terminate due to the appraisal, saying, I don't really care what it appraises for. I want this house so bad that we're gonna buy it and we'll come out of pocket for the rest of it. Okay, so tread lightly with this form. Talk to me about it if you have questions. Don't just have your client sign it. Okay. Last but not least, the amendment. So this is not an addendum to the contract. Once you have all signed, executed, under contract, all is good. If anything needs to be changed, you will do an amendment to the contract. There are different ways to use this one amendment, but if you use one, you can't use it and it's executed, you can't use it again. You need to use a new copy of it, okay? So keep that in mind. It's okay if you're gonna change the sales price, and so you have amendment 1 to change the sales price. Then you have amendment 2 to change the repairs, because now we did an inspection and we want them to do a plumbing test, want them to fix the foundation, want them to fix the windows. If that's executed and you need a third one, if you needed to change the date, the closing date needs to move back 3 days. You need a new amendment. So you can have multiple amendments to a contract, okay? Now, if you have one amendment to change, we're gonna need to change the closing date and the cash price because the lender said so, or whatever. You all agree you can have that on one amendment. You don't have to have a new amendment if you have multiple things, unless the lender requires it. But Section A is sales price, if you're going to change the price of the home. Section B is repairs, and sometimes you have too many for that box, so you can just put C attachment A and create an attachment A. Section 3 is the date. Paragraph 9 is your closing date. You guys need to know what the paragraphs mean, okay? Paragraph 12A1, that's if you're asking for concessions. So at first you didn't ask for concessions, then you did a repair amendment, and you're like, these are easy things, we're just gonna ask them for $1,000 in cash. That's what you might do there. Lender required repairs or treatments. That's just how much it's gonna cost and how much the seller is gonna pay. The buyer has paid the seller an additional option fee of $10 to extend for 2 more days or whatever the case is. If you need to extend option. If you waive the unrestricted right to terminate during an option fee, all of a sudden, if the date for the buyer to give the notice to the seller that the buyer cannot obtain buyer approval. So right now we gave 21 days, maybe you want to extend it a couple more days, then you would do that. And then other modifications, 9 would be anything else that you need to change in the contract, you can put in Section 9. Remember, factual statements only. Don't try to be a lawyer. Execution. This needs to be executed because it's amending the contract. It's changing the contract. The last person to sign puts that date, and it does not have to be me. Okay? Yay, we finished. I'm sorry that took so long. We will go another contract day where we're not going through all the amendments, but we'll be looking at other things. Everybody who's online, I know that was painful and long, and we expected it to be a little bit shorter, but I'm going to sign off. This will be listed in our page.